I do this long enough and I appear smarter than I really am. You flunked your drug test. You know you have them. Nobody knows, but you got meth in your system and amphetamines in your system, which is not surprising since you got 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 prior convictions, not the least of which is illegal possession of a controlled substance. Right. All right. You're well, you're free falling, Travis, and this isn't going to help you by being inebriated with drugs. Your bond is revoked, and your bond is $30,000. You must have a drug patch as a condition of your bond. So we will test you all the time. The next time you fail a drug test, I'm going to put you in, and the bond is going to be so high you won't be able to make it. It's just the way it is. That's what we have to do to help you be the best person you could be. That is drug free. That's what we're going to do. But you're free falling. This is a conviction here would be your 11th felony conviction that we know of. Few people come into this courtroom with double digits in prior convictions of felony. And you're a very old person. Are you 50? Now, this year? Well, you're old enough to know better and act better. But that's what we're going to do to try to help you be the best you can be. But it's not being the best you can be by continue to commit crimes and to have a problem with methamphetamine. We all know is too often a problem in this room. Maybe y'all can fix something out. You can figure out something that can help him with the source of his bad choices. Okay. Otherwise, what do we do? The next event is
because we still got to work on that drug test coming back. Not drug test, that lab coming back. That's why you did 4 weeks waiting for a lab.
Yeah, I know, but I got what I need there.
Well, yeah.
With the drug test here today. But well, I mean, we can wait, but
I can talk to
it doesn't really matter.
Right.
He's coming into court high on, he's got methamphetamine in his system when he comes to court. This is supposed to be a responsible choice.
That's just great. I didn't.
I don't care, sir. The tests are scientific. And I wish I had $1 for every time people fail the test and they go, I hadn't been around it. It's not the scientific test, we all know people with a drug problem are in constant denial. You're constant denial, but you test positive. There it is. And that's what we're going to rely on, science. But you have a history of this. And that's the rulings of the court, and we'll see you back in a few weeks, right?
Well, that'll be fine.
Okay. If not, or sooner, if y'all try to work something.
I'll give a call.
Thank you. That is all. Brent, what do you have?
Stacey Kim.
Ma'am, sir?
Start talking with him.
Okay, you don't need me.
No objection.
Okay, we're in recess until when? Is it
1:30.
1:30, everybody? See you this afternoon. The 1 and 2 constitute a state jail felony, right? Paragraphs 1 and 2.
Yes.
And then he's got 2 state jails.
Talking about the original paragraph
The
and
bigger ones like that, some paragraphs.
So that makes it a state jail felony punished as a 3rd degree, right?
yes, Judge.
So
He said.
you're Marcus Miles. In 25 CR 1635, what is it? Announcement.
Yes, Judge, Mr. Miles is dissatisfied with my services and would like a different lawyer.
So it has everything there.
Why?
And all the doctors.
Because I feel like
Go back
I'm being incriminated,
That's not the word.
criminalized,
That's not criminalized
criminalized
again.
with malicious intent. You know what I mean? I feel like because I'm
Okay, well, he's not the one that brought the charge. The grand jury did.
I mean.
Not him. The grand jury brought this charge. He's trying to help you.
Yes, sir. They did let me go. Yeah.
Huh?
They did let me go from the house, and I didn't know, which they told me the case had been dismissed. Your
Oh, but that's why God invented trials. They say there's an issue. They contend the indictment is correct. He says it's not right. You're not guilty. That's where we are on this. That means it goes to trial.
Judge, just for clarification, this case was re-indicted to correct one of the officer names in the indictment. So there was a dismissal and a re-indictment, but it's the same case. Just for clarification purposes.
It was dismissed because it was
Re-indicted.
mistaken. There were some mistaken words and then you re-indicted it
Yes.
to correct it.
And this active case is the re-indictment.
Well, all I've got is just this one, 25 CR 1635. That was
Because the other
Indicted
case has already been
October.
dismissed.
29, right?
Yes, Judge.
Okay. Yeah, that's what this is. But no, you don't get to, you don't, did you hire him? Or he's, no, you can't just fire them like that. You can hire anybody you want and that's your choice with your money. But all you get under the law is a competent lawyer, which he is. He's a fighter. He fights for people. But you don't get to change lawyers because the law's already been ruled on that. If you start that, you could do it all day long for the next 100 years, change lawyers, and we'd never get anything done. Well, the Supreme Court said that's not the way it works. You're entitled to a competent lawyer, and he's very competent. Now, I want to know, what do y'all want to do? Is there an offer that he's going to consider, or do we have to go to trial? That's all I need to know.
There's been one relayed, Judge.
Okay, and you related it to him,
I
Brent?
did, Judge.
And he says he wants a trial, which he has, that's what this Constitution says. You get a right to a trial. You don't get a right to a plea deal, but they still make plea deals. You don't have to take it, but this is your day. You got to tell me which direction you want to go. If you want a trial, you get it.
You know what, Your Honor? I'll sign for the plea. I'll sign for the plea.
I understand what he's
That
saying.
was-
Years is the.
Oh, the
I'll sign
offer?
for the-
Yeah.
I mean.
Okay, all right, we'll write it
At
up,
first,
Brent.
like two,
Write it up.
I did say two at first when I had my other lawyer.
Well, that's what, well, were you negotiating with them?
No, I've just been
I
on
think
the
that was
case
Mr.
with Brent.
When I had my other lawyer,
David.
David A. Grove.
Okay, well,
That was also not my case at that.
that's not her case, but that wasn't before me. It didn't come before me. So what happens is when they re-indict, I mean, it's a new game between lawyers.
I wasn't on the case, so I can't speak to whether.
Well, she said she's
They don't
after
have any
3 years.
notice
If y'all want to do that,
Yeah.
write it up so we can go. How long have you been in jail?
I've been in jail.
How much time is
As
this
far as
credit?
they say.
I'll tell you exactly. She'll tell you exactly. So you know where you stand. You get credit for all of that, Marcus. You know that. You don't.
I'm just tired.
And then, yeah, and then you still get good time, and you're parolable. You'll get paroled at a certain time, and this is not an aggravated offense, so it's a quarter of the time. You could get paroled in a quarter of the time. If it's 3, that's 36. You know, 4 into 36 is what? 9 months. That's what that's what you're gonna have to serve before you parole.
77 days.
So you got 77 days, she says.
Judge, it's 120. I called the jail this morning. They had.
He was-
Any other case.
Yeah, he was
So they
rearrested.
brought it back to the other?
Yep.
Okay.
It's probably to show on this current cause number. I talked to the jail this morning.
Yeah, that's an unofficial number.
Yeah.
I do more research when I get in the back when I actually do.
I talked to Miss Katrina Keel.
Oh, okay, yeah.
She says-
Yes.
She was telling you how much credit he has?
Yes, sir. I called this morning. It's about 100.
Okay, whatever.
No, you're good. I know you're doing it now.
Yeah.
Sometimes they don't give them
I'm sorry.
at the end of the day, the jail people have the right numbers, not us. But they give us data and sometimes they don't update data. All right, write it up and let me know when y'all are ready and we'll move it. Thanks. Joel Vasquez, John West, Stephen Allen. Brett, when are y'all ready?
Mr. Miles is ready.
Okay, let me take this one.
Sure, thanks. Broke up the pleas and stuff, so I need to find you.
Mr. Miles,
I need the queries.
you're gonna, please come over here. She needs your fingerprint. Thank you.
She got a thumb.
Oh, I could. Yeah, big fan of today's.
Like running a race in Death Valley.
Mr. Miles, please raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, yourself, you got? Okay, either your right hand, friend.
Erica, we're doing a plea on
Place that right here.
Yes.
Sit down.
Miles.
One time.
It was, but then.
Sit down. Okay.
You're more than welcome to sit here.
Okay. You can go to.
25 CR 1635 is now called the State of Texas versus Marcus Miles. The defendant is present with Mr. Turk, his attorney, and the state's attorney. Does the defendant waive a formal reading of this indictment and the arraignment here? Can we proceed in summary?
Yes, Judge.
Summary, Mr. Miles, this indictment alleges in paragraph 1 that on or about May 23rd, 2024, in Jefferson County, Texas, you committed the offense of evading arrest or detention. And in paragraph 2, it goes on to allege that you have 3 convictions previously of evading arrest or detentions. So, police officers, and paragraphs 1 and 2 thus constitute a state jail felony. Do you understand? But we go on to allege, they'll go on to allege you have 2 prior convictions of state jail felonies, one in 2014 in the 252nd District Court of Jefferson County for theft of stolen property, and then another one in this court in 2021 for illegal possession of a controlled substance. And did you fully review all of these allegations? So paragraphs 1 and 2 constitute a state jail felony. 3 and 4 enhance the state jail felony punishment to as though it were a 3rd degree felony. You're punished as though a 3rd, but it will say state jail felony punished as a 3rd because of these additional convictions. So you are looking at no less than 2 nor more than 10 years confinement in prison and a fine up to $10,000 as the punishment range that is possible. Do you understand?
Yes, sir. Get simpler this time, Judge.
Well, using English would have helped me. So this looks like Mayan.
It does, but after about 20 minutes of
Hieroglyphics.
trying to get that pen to work,
I
gave up.
look, I always complain about it. All right.
It just says enhanced to 3rd degree 2 to 10. I reviewed it with Mr. Miles. And since it's not a probation, I've marked out those paragraphs, and since it's not a state jail punishment,
Okay.
I marked out that one.
So what I'm gonna do up here is, and the agreement here, even though it's no less than 2 nor more than 10 years confinement in prison, the agreement is your sentence, you will be pleading guilty to paragraphs 1, 2, 3, and 4, sentenced to 3 years in prison, given credit for all time you have served. Is that your understanding of the plan?
Yes,
If I follow this agreement, you have no right of appeal of your case. Do you understand, sir?
Yes, Your Honor.
How do you plead to paragraph 1, guilty or not guilty of evading arrest or detention? Guilty.
Guilty.
Paragraph 2, which goes on to allege those 3 prior convictions of evading arrest or detention. Or are those allegations true and correct as they are alleged?
True.
And are you pleading true and correct of those allegations voluntarily? And finally, paragraphs 3 and 4, those prior convictions, state jail felonies in 252nd and in this criminal district court back in 2014 and 2021. Are those allegations true and correct as they are alleged? And are you pleading true and correct to those allegations voluntarily and because they are true? That constitutes, as you know, a state jail felony, though punished as though it were a 3rd degree felony. Thus, the punishment range no less than 2 nor more than 10 years confinement in prison and a fine up to $10,000 can be assessed. And the agreement that's been reached with you and the state, you would be pleading guilty, sentenced to 3 years in prison. How do you plead to all of this, guilty or not guilty?
And just like that, the decision is made. After everything we've watched, the case changes instantly with a single word.
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
And then these paragraphs 2, 3, and 4 with those prior convictions, as we discussed, are those allegations all true and correct? And are you pleading true and correct to those allegations voluntarily and because they are indeed true?
Yes, sir.
I'm going to show you what's marked as State's Exhibit 1. Did you sign that document voluntarily, understand it, discuss it with your attorney? Are the contents all true and correct?
Yes.
State's Exhibit 1 tendered into evidence without objection admitted. This states you are mentally competent to enter your guilty pleas there, and pleas are true here. These are done freely and voluntarily. You understand and appreciate the consequences of pleading guilty. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All of this is true. It states so help you God.
Yes, sir.
State's Exhibit 1, part of the record for all purposes. Pre-sentence report is waived here.
Yes, Judge.
I will find as follows that the defendant is pleading guilty to paragraphs 1, 2, 3, and 4, which guilty to paragraph 1 and true to paragraphs 2, 3, and 4, which constitutes a state jail felony, punished though as a third-degree felony. He is mentally competent to do so. He understands and appreciates the consequences of pleading guilty. There's sufficient evidence supporting his pleas of guilty and true to this state jail felony, punished as a third-degree felony. From State's Exhibit 1, he has pleaded to and signed to support his guilty plea. That is enough to find the defendant guilty beyond a reasonable doubt of this state jail felony, punished as a third-degree felony. I so find for the record, and he is guilty beyond a reasonable doubt. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 3 years. And of course, you will be given credit for all time you have served in accordance with this case. Anything else, State?
No, Judge.
Yes, Judge, just to make sure that I'm fairly sure the record's going to be clear, but I know since this was a re-indictment, I want to make sure that the record reflects that he should get credit from cause number 24 DCCR 1680, which I think in total, as per the Jefferson County Jail's
I
warning,
think it does.
is 120 days. Just making sure.
Yeah, you can't serve any time and not get credit for it. Somehow,
Well, I just want to
you
make,
got to put it together, and that's I believe the practice of the state. If there is a problem, call him up, raise it so we can fix it. But it's all fixable. But because they're going to be looking at different documents, it's still it's only proper that you get credit for time you have served. You should never serve a day in jail and not get credit for it. Anybody, unless they did bad things.
They have to give me all of that. You gotta give you that. They gotta give you that every time.
Oh, I don't think there's a doubt about it. And if there's a problem, I can fix it.
Yeah.
Okay.
Serve the time in connection with this offense.
I just want to make sure since they're two different topics.
The case is not what we look at.
What was he indicted with the first time?
Same.
It was the same case.
Okay.
Yes, Judge.
Okay. Sometimes when there's different charges, they have a charge at the beginning, then they drop it. And sometimes that gets confusing, but it should not be a problem. It's the same charge. You got to have credit. You got to get credit for time you spend on a charge. Okay. Anything else? That is all. Thank you.
Judge.
And just like that, it was over. One defendant learned that repeated bad choices only lead to tougher consequences, while another accepted a prison sentence instead of risking an even harsher outcome at trial. What do you think was the biggest turning point in today's courtroom? Let us know below.